clipped the rear of a school bus, causing the bus to flip on its side and land on the plaintiff's vehicle and crush the roof of the plaintiff's vehicle. Mr. Summerall, you represent Raintree?
Yes, and the driver.
And the driver. Who are the other parties that are in the case? Who are they represented by?
They are settled, is my understanding.
I think, Your Honor, we just did a dismissal with regards to Atlanta Public Schools, APS, and their driver, Yolanda Brewer. So they're no longer part of the case.
Who is John Doe?
There is no John Doe at this point, and I don't know that there's going to be one. I think it was filed out of an abundance of caution at the beginning of the case.
All right, how much are what are the injuries to your client, Mr. Braun?
It's a fairly significant head injury, or at least allegedly. We've got a fairly significant head injury, PTSD, things of that nature. There's also a physical component to it.
How much are your medical bill?
Oh, I think we just supplemented 100 something thousand and some change.
You're complaining that, well, first of all, the day of the accident, there was a drug test. No, let's see, the accident was in October. In November, there was a drug test. Is that correct?
I'm sorry, Judge. I think the accident was November 10, 2016.
Okay, and the drug test was the same day. It was inconclusive.
Correct.
What examining physician rejected it?
It was one of those, it wasn't Concentra, but it was something similar to that, I think. One of those places. And Water, if I may real quick, I'm not sure if this helped or not, maybe shorten some of the issues. When we originally filed the motion, we filed it based on spoliation of evidence, not knowing, we requested the driver qualification file and a whole bunch of other stuff.
You wanted the maintenance records of the truck.
And the maintenance records of the truck.
From what I've seen, the responses of the defendant are not, they seem somewhat disingenuous.
Well, that's part of our problem, Your Honor, is that when we originally filed it, we didn't know what documents they had or didn't have. Comes to find out, so that's why we thought that they had spoliated a lot of stuff. Now it turns out in their response that they never had most of the stuff. And so the spoliation document really probably only applies to the employment application, which they've admitted to having and no longer having. And then the maintenance.
Let me ask you this, sorry for interrupting you. The employment application, they can tell you at least what they ask people then and they ask people now. Is that basically what we're talking about?
It does, but we don't. But Your Honor, we've got at least one document that the defendant has already admitted to lying on, which was his medical certification. And he admitted to lying about a back injury in that certification. That's why these documents become important, because we already know he's a liar, for lack of a better way to say it.
Well, he was fired in 2018 for lying on his Department of Transportation physical examination. Is that correct?
That is correct, Your Honor.
And that's what you're talking about.
And that's the document that he lied on. He had only been working for Raintree for 3 weeks. He lied. He had been out of work for a period of time with a back injury before that. He went to go reapply to Raintree. He filled out his employment app. They hired him based on prior relationship with their safety manager. They did none of the required DOT, FMCSA stuff, and all they had was an employment application.
That's your negligent hiring and retention and training and supervision, right?
And entrustment, Your Honor, but yes.
And then you're claiming they didn't, is there been something diagnosed as inappropriate about the truck, the maintenance or the repairs? Is that a red herring in the case, Mr. Summerall?
There's nothing there, Your Honor. Nothing there at all.
Let me ask you all this. Are we open to mediation?
We've requested mediation. Plaintiff said no.
Your Honor, I think we would certainly be, here's the problem. We went to mediation once, and this was actually before I was involved in the case. And it was a $25,000 or $75,000 offer, I think. and that was cumulative with the two defendants.
But here's what I want. I want an experience, and I appoint mediators all the time that I'm comfortable with. And I want an experienced, well-trusted, well-qualified, well-respected mediator in the case that has credibility of both the plaintiff side and the defense side. And one that I have had good work with is Joe Murphy at Miles Mediation. Do y'all know him?
I do.
I just set up a mediation with Joe Murphy Friday of last week. So yes, we know.
Is that somebody y'all could live with?
I could live with Joe, Your Honor.
Mr.
Certainly.
Summerall?
Absolutely.
I don't want to listen. We're backing down from a. I don't want to put words in your mouth, Mr. Braun. We're backing down from a striking of the answer position at this point. Is that correct?
I think so. I think it's more of a jury charge issue on the document, because I think most of the documents were not spoliated. They just never existed in the first place.
What about some of these answers? Defendant's not in possession, see daily logs, defendant's not in possession. Is that something, Mr. Summerall, we can narrow down and try to provide?
Well, Your Honor, absolutely. And look, if I can but just put a few seconds of background here. We got this letter notifying us of this case a week after the accident occurred. It simply said, your driver hit someone from behind. There's no request and no mention of a negligent retention claim or a maintenance claim. The lawsuit was filed 2 years later. And that was our first notice that those claims were being made, but no discovery was requested. Mr. Braun wasn't involved in the case yet.
Who was involved before that? Was it another lawyer?
Yeah, Melody Cherry. Didn't even send interrogatories or requests for documents to Raintree at all. Never requested Raintree's deposition. I mean, this stuff, Mr. Brown doesn't know any of this stuff because no one's ever requested that deposition until he got involved some 17 months after the case was filed.
Work together and pare down some of these holes in the discovery, Mr. Braun?
Yes, Your Honor. Like I said, I think a lot of it was resolved when in Raintree's response to our motion, where they admitted to not having most of this stuff. And as opposed to, and I shouldn't say not having it, never having it. So a lot of the documents that we've requested, they've already admitted they didn't have a driver. They don't have a driver, a road test, a written road test. They don't have a pre-employment drug screen. They don't have a lot of the stuff that we requested. So it's now turning into those things are going to be subject to a punitive claim for not following the FFCSR. The spoliation motion that's presently before the court really only applies to the application and then to the maintenance records. And to address what Roger just said, these are things that are required to be kept by the law, Your Honor. It's not a question of us telling them, hey, we need these things. The law says you've got to keep that employment application for 3 years. That's where the violation.
Does the person only worked for you, Mr. Summerall, for 2 weeks? Is that right?
He was only working for us for 3 weeks before the accident happened. He worked a little while afterwards.
And he's admittedly lied, and that's why you fired him.
We found out when he got an inspection by one of the DOT doctors later. We found out that on a prior inspection, he had written down that he had not checked the box that said he'd had prior surgeries. That's the lie. He had a prior surgery, and on an application, he didn't check that he had. Excuse me. So
let's do this.
That was the whole
See if
purpose.
we can supplement the discovery. Let's see if we can narrow the gap on the discovery. Do we need to do any more depositions or anything like that before we can mediate?
I mean, I think we could mediate at any time, Your Honor. I'd like to do Mr. Martin's deposition. I think we've got it scheduled for mid-July, July 16th, but we can mediate without it. I mean, again, we don't have the documents, and I don't think they have.
Let's work to fill in the holes of discovery. Let's work diligently. We have two fine attorneys with fine reputations. Let's work together to fill in the holes. So I would assume at this point, you're withdrawing your motion to strike the answer for spoliation, but you're still reserving your rights to request the disputes, whatever disputed discovery there still is, right?
No, Your Honor. Unfortunately, I'm keeping the motion for spoliation. I don't think the severity of it arises to striking the answer. I do think it rises to the level of getting a jury charge on spoliation.
All right, let's reserve that for if we get to a jury trial of dealing with that. Can we do that?
Yes, Your Honor.
All right, so let's reserve any issue of spoliation with all rights. I want you to work together on your discovery. I want to mediate it with Joe Murphy, not to see what the offer will be, so he can tell you, in his opinion, what he thinks a good number for the facts of this case is. So I mean, the point of it is not the point of it is a fresh set of eyes, unbiased eyes to tell you what he or she thinks.
Right.
That's my point. And I think we're all on the same page there. So let's reserve this motion for a later date.
Judge, can I, this doesn't affect mediation. I think we can go ahead without mediation, but just in terms of timing, I don't want to come back later and have you say, well, why didn't you tell me at the time? Just so you'll know, there've been a number of additional medical providers listed lately. We're cooperatively going about getting those records. I haven't seen all of these records yet, except for one neuropsych test that's been done. And then we're going to have to maybe have some time to respond to that. So
I gave you all the time you want. But what I want to know is narrow the issues. I'm easy to work with. I'll give you all the time you want. I think, Mr. Braun, that what he's asking for is to tell him the number of the medical bills for each provider and what their services were and what their diagnosis was, so that at a later date he may depose them if he wishes, or at least so that he has an understanding of what to expect down the road if mediation is not successful, and so he can make an informed decision in mediation. Does that make sense?
And I'd like to see the records before mediation. We still don't have those, and obviously that's going to be real determinative of how my client views this.
We were mediated with Joe Murphy probably until August at the earliest.
Yeah, because you can't get Joe anytime soon anyway.
So I want y'all to, one of you to do, just submit me an order, Mr. Braun, that says you're reserving this motion for a later date with regard to a jury charge, possible jury charge. And the other thing I want your clients to understand is nobody knows when a jury trial is going to happen again in this building. And we do know that whatever is going to happen is going to be statutory criminal speedy trials. Okay. And so maybe that'll help us try to resolve it. But as opposed to discovery and deadlines and depositions and the like, I'll give you all the time you want, provided we go to mediation in good faith, open mind, and reasonably. Okay?
Judge, can I make a suggestion real quick? Since you'll be taking over the family docket on July 1, it may make sense to not only do an order as to reserving the motion, but also maybe a revised scheduling order at this point, giving more time for discovery, giving a deadline for mediation and all of that, because that way we've got something in the record for Judge Whitaker when she takes over.
I think that's a good point. So Mr. Braun, how many more medical providers are there? 5, 6, 4? How many?
There were quite a few, Your Honor. I don't remember.
I believe it's 5.
I tell you, we're working towards getting them ourselves. These were providers we weren't all.
Let's put in the order. Let's put in the order that we'll work on these additional medical providers' reports and their diagnosis and their fees before the mediation. We'll have that. Mr. Summerall will have that we mediate it hopefully by the end of August, if not by the end of September. We continue to do discovery. We say that discovery ends at the end of the year or something. Is that okay?
I think that's fine, Your Honor.
And are there going to be any dispositive motions? I assume not.
Not Your Honor, I don't think so.
I believe, yes, there will be, partial, not fully dispositive.
Okay, so let's say that we'll try to mediate it no later than the end of September. Discovery will end by the end of December. And that we'll file any dispositive motions by the end of January. And we'll hear those motions hopefully sometime in March, and then go on a trial calendar, hopefully in April. Okay, but I do want to get the mediation scheduled between now and the end of this month with Joe Murphy, because I think that would be helpful. And then I start doing the family division. So if any of y'all want to be family lawyers, come see me.
Thank you, Your Honor. But
Good for you.
So, but anyway, it sounds like to me y'all are working together well. You're getting along. You're being respectful and courteous and professional. And I would expect nothing less than that based on the reputations of both of you. I don't believe I've ever had a case with one of them. Have I had a case with either one of y'all?
I think it's been it's been a long time.
All right, well, let's see what we can do. Now, Mr. Summerall, is my young friend Carrie Moss over there with you?
She is.
She's dating my chiropractor.
And
She's asked
I
me
know
to
him well.
already.
He's a great guy, Nick.
Yeah, he's a great guy. Now, she can't hear me, can she?
No, she cannot.
There's a fancy diamond coming soon.
Ooh,
I've been working on that with him.
Do I know something she doesn't?
Exactly.
Let's stay secret.
Well, y'all take care, and I appreciate y'all's courtesy and professionalism, okay?
Thank you both.
Thank you, Judge. We appreciate it.
thank you, Judge.